Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and we're continuing to learn about organizational choices. Today's episode is all about the limited partnership, a structure designed to separate money from management. And it's sort of a bridge into the form that really separates ownership and control, the corporation. So if general partnerships are flat and informal, limited partnerships are somewhat the opposite. They're hierarchical, deliberately. There are different types of partners, limited partners and general partners, and they're built for situations where one person or group puts up money and somebody else has the responsibility of running the business. So let's break it down using our 7-issue framework. What is a limited partnership? A limited partnership is a formal business entity with two types of participants: general partners who manage the business and bear full liability, and limited partners who contribute capital. They don't manage the business, and in return, they get limited liability. The structure is especially popular in industries like private equity, real estate funds, venture capital, and film financing, where investors want exposure to upside, but they don't want daily control and they can't tolerate downside risk. Unlike general partnerships, limited partnerships require a filing with the state to be valid, so you can't create one by accident. Let's talk about formation. To form an LP, you must file a certificate of limited partnership with the Secretary of the State, and we'll see this as a theme. In general, to form anything but a partnership, you have to file a certificate with the Secretary of State in the state in which you want to incorporate or form. The filing includes basic information, like the business name. It has to identify the general partner. Limited partners are usually omitted from the public record, by the way, which is another advantage for limited partners. They don't have to be publicly identified. In addition to the filing, a limited partnership agreement is required. The document governs how the business operates, how profits and losses and control are allocated. So, filing is simple, but there's a little bit more to it when forming an LP because since we have these two classes of people, we have to have some type of agreement regarding how they're going to interoperate. If you don't form one, by the way, there are some default rules that would govern, but given that there's a lot of money at stake here, most people would hire a lawyer and draft up a limited partnership agreement that sets forth the terms. Let's talk about liability. General partners in a limited partnership are fully liable, just like in a general partnership. That's why they're called general partners. Basically works the same way in both cases. Limited partners, on the other hand, enjoy what we'll call limited liability, which means a limited partner could only lose what the limited partner invested. They can lose their entire investment because the organization could go bankrupt, but they can't be held personally liable for any additional debts from the business. Creditors can't go after the limited partners. Under older versions of the law, limited partners could lose that protection if they got too involved with management. But modern statutes, like the 2001 revision of the Uniform Limited Partnership Act, eliminated that restriction. So today, limited partners can provide advice or vote on big decisions without becoming personally liable, usually. But again, if that's your goal, that may not be the right choice for the particular organizational form. The idea here is that limited partners are passive. That's the design. And that's the reason we would choose this form. Let's talk about control rights. Control in an LP is highly centralized. General partners make all the decisions. Limited partners generally have no say in daily operations. However, the partnership agreement could expand the limited partner's rights. For example, the LPs might be required to approve major decisions or to elect new general partners. In practice, control often lies with a single general partner entity. Frequently, there is a corporation which is created solely to manage the limited partnership. In reality, then, the general partner is not a human being, but another artificial entity. Why might that be? Well, it eliminates liability. So if the general partner is liable personally for all of the debts and torts of the partnership, but that is a corporation, the liability stops there. And the corporation effectively blocks the liability from flowing to any humans. As an aside, this is sort of a historical workaround that has been obviated somewhat by the use of limited liability companies to perform the same goal. but we'll talk about that when we talk about limited liability companies. Moving to financial rights in limited partnerships are usually proportional to capital contributions, but again, this should be negotiated and documented in the partnership agreement. The idea, of course, is that limited partners invest a certain amount and expect a certain return. And so, in general, the structure would be that profits go to limited partners first. And these function kind of like preferred returns, which get distributed before the general partners get anything. Any remaining profits are divided among the general and other limited partners, usually per their agreement. This is kind of like the situation in a venture-backed company, where you'd have preferred stockholders who get paid first, and you'd have common stockholders who get paid last. Losses, by the way, are also shared, but unlike in a general partnership, limited partners are only liable up to their investment. Remember, unless there's effectively veil piercing, there's a limited liability shield, which means that you can't lose more than you invest. Let's talk about continuity. Limited partnerships were seen traditionally as temporary investment vehicles and were designed to have fixed end dates. This is actually preferable because the idea was that you would want your capital back after some period of time. The one I'm most familiar with is venture capital funds, traditionally structured as limited partnerships, and they have a 10 to 12-year lifetime, after which point the capital has to be returned. So they're not generally designed to live forever, and since they were traditionally seen as partnerships under traditional law, they would only exist so long as they had all the same people. Now, modern statutes treat limited partnerships as separate entities. So nowadays, the withdrawal of a partner, even the general partner, doesn't automatically dissolve the business. But most limited partnership agreements specify how and when the partnership winds down, especially when you have a fund with target exit dates. So these are not designed to operate in perpetuity forever, the way a corporation would. Liquidity is how easy it is to transfer shares. Limited partnerships are not liquid in the way corporations are. You generally are buying in for the length of the fund. Limited partners can transfer their rights to profits, their financial rights, but they usually can't transfer control rights, and frankly, they usually don't have any to transfer. Anyway, general partners likewise cannot generally transfer their control role, without the unanimous consent of everyone in the partnership. And the idea is we want to preserve a relationship between management and investors, which is a select group of people that have decided deliberately to work together under this structure, making it difficult for anyone to unilaterally change that. So they're illiquid. And finally, regarding mergers, limited partnerships can merge with other entities, but frankly, it's complicated. We require unanimous consent unless the partnership agreement says otherwise, and they're just not designed to do this. They're usually designed as investment vehicles structured to last only a few years or a decade, so mergers are really not that common. What you might have is that whatever they've invested in merges with something else and generates a return on capital. But this is not a whole full-blown course on M&A, so let me just say that limited partnerships, of course, can merge with other entities, but it's not that easy. They're not designed for it. And if the goal is to build something for sale as opposed to a return on investment, you're probably looking at a different formal choice. So what's the bottom line on LPs? LPs are purpose-built for investment. They're strong on liability protection for investors. They're weak on liquidity, and they have very little flexibility around control. They're a traditional choice when you want to raise money from passive investors while retaining centralized management and get flow-through taxation benefits that partnerships enjoy. However, in some cases, this has been obviated by the LLC form, which we'll talk about subsequently. So if you're a traditional investor, you might be familiar with the limited partnership form as a way to invest money in private business. Nowadays, there might be alternative forms for that. And we'll talk about those additional forms in future episodes. In our next episode, we'll tackle corporations. Those are the workhorses of modern business, and talk about how they centralize power while protecting investors. And until then, just remember, law doesn't just regulate business, it organizes it. I'll see you next time.